Ladies and gentlemen, welcome to another edition of Democracy and the Rule of Law, a show where we delve deep to the critical issues of politics, governance, and the rule of law. In today's episode, we'll be looking at two critical issues that have made headline within the week. First, we'll look at the issue surrounding the nullification of the Rivers State 2024 budget, the one that was recently passed by the governor. It made headline last week that it was nullified by a competent court of jurisdiction that the budget was not properly presented and passed, and it should be repassed by the properly constituted River State House of Assembly. So we'll look at the issues concerning that scenario. Secondly, we'll also look at the Plateau State House of Assembly crisis. If you recall, last week we looked at the judgment of the Supreme Court vis-a-vis the part affecting the legislators that were sacked by the Court of Appeal. And of course, there were solutions preferred that they could seek for interpretation of the Supreme Court judgment as it relates to their seat. But during the week, we saw the confusion, surrounding that situation where the sacked lawmakers, went to occupy their seats, basing their decision on the Supreme Court judgment. That the Supreme Court judgment had effectively reinstated them and nullified the Appeal Court judgment, sacking them. And there were a lot of confusion surrounding that. We will also look at that issue. And lastly, we'll look at the renewed war against corruption. We'll look at by the present administration. We'll look at the issues also surrounding that. We have eminent learned friends in the studio who would help us make sense of all of these issues. I am Barrister Kenneth Wimo, your host for today's show. We'll go on a very short break, and then we'll return. We'll introduce our guests who are already seated in the studio this afternoon. Stay tuned. We'll be back very shortly.
Month of November 2023, a three-man panel of the Court of Appeal, presided over by Honorable Justice Oluwayemisi Williams Daudu, sacked not less than 23 Plateau State lawmakers elected on the platform of the People's Democratic Party (PDP) in both the state and federal legislative houses. The state governor, Caleb Mufwang, was also not spared, as his declaration and return by INEC was also nullified by the same court on 19 November 2023. Dramatically, the Supreme Court overturned the nullification of the election of the governor, while the lawmakers are stuck in the middle because the journey of their case ends at the appeal court.
I don't see any contradictions in both judgment of the Court of Appeal and also that of the Supreme Court. Now, the Supreme Court's statements as to criticizing or scolding the judgment of the Court of Appeal, sacking the lawmakers at the state level, is just a mere obiter.
Because of these exigencies of time and the plethora of cases, they restrain it to the Court of Appeal. So now, all the jurisdiction of courts regarding the election matter of the House of Assembly, State House of Assembly, terminated at Court of Appeal. And that is what happened in Plateau State. So if the lawmaker in Plateau State now, who was sacked by Court of Appeal, now saying because the governorship election have been overturned in favor of their governor, hence they too they want to resume office, that is invitation to anarchy.
The rules of court are a set of procedural regulations adopted by courts which must be followed by parties and their lawyers on matters within the court's jurisdiction. The decision of the 16 Plateau State lawmakers not to abide by the appellate court could be an invitation to anarchy.
So the lawyers have duties to ensure that the cases are well presented before the court, the evidence are well annexed, and the necessary witnesses are assembled with a view to convince the courts to see reason why they should go in a particular direction within the law. So, and again, it is justice according to law. Okay, so if you are saying the last overcome man is court, yes, it is, but the courts cannot descend into the arena.
We do respect to some lapses we observe in respect of current issue regarding the judiciary. I'm not saying everything is perfect, and you should know that those people there too, they are not angels. They are about to commit error and mistakes. Understand? But we should not, because of that, now not throw away the baby with the water. Understand? Look at the issue of Kano. When there was a mistake in the satisfactory judgment, satisfactory copy of the judgment from Court of Appeal, the whole place was agog in noise and all that. The Supreme Court laid the whole matter to rest.
To ordinary Nigerians, they believe that the court should be a problem solver and not problem creator looks bleak, considering the opportunity afforded the governor to proceed to the Supreme Court to challenge the appeal judgment, while the lawmakers are incapacitated and left in the cold base on the same alleged lack of party structure.
They can still test the ground by approaching the federal court for interpretation. If they are confused or they are not sure as to whether to rely on the obiter made by the Supreme Court or to rely on the substantial matter before the Court of Appeal that has now sacked all those lawmakers, they can go to the federal courts for proper interpretation. But as far as I'm concerned, nothing can come out of it.
Well, they should not waste their money, because if you say you want to take application to Supreme Court, you know what Supreme Court is doing now? They can even find the lawyer that will file that kind of application, because you become abuse of court process. They've told you by the electoral law, your election matter stop at this court. If you take it beyond that level, you'll be fined.
Back, if you are just joining us, you are on to your favorite program, Democracy and the Rule of Law. On the show this afternoon, we have Barrister Deji Olaleye as a guest. Barrister Deji, welcome to the show.
It's a pleasure to be here again. Thank you.
Also, we have Barrister Adekunle Ojuese'en on the show this afternoon. Barrister Adekunle, welcome, sir.
Thank you so much. Only that I would prefer doctor to barrister. In fact, I don't even like lawyers being called barrister, personally.
No problem.
Good afternoon. Guys back home.
All right. Welcome, sir. So, without wasting much time, we'll go into the nitty-gritty of today's episode. So, first of all, we'll take the issue surrounding the Plateau State House of Assembly crisis. You know, we had the opportunity to extensively discuss about the Supreme Court's judgment concerning the governor, and also the fate, of the House of Assembly members and, of course, House of Rep members who have been unjustly, in quote, unjustly, sacked by the Court of Appeal. Unjustly because the Supreme Court had said that justice was not properly dispensed in that judgment. So I guess I'll be permitted to use unjustly sacked. So we'll look at it because at the end of the day, this issue has not degenerated into crisis, because both the sacked lawmakers and the ones that are now supposed to be the lawmakers wanted to occupy the assembly this week, and there was confusion on who is the right person to be addressed as honorable members of the Plateau State House of Assembly. So, Dr. Adekunle, what do you have to say concerning all of this issue, and what is the way forward, given the circumstance of what is happening now?
Well, in all honesty, the fact that people seem to be confused, it's just a self-imposed confusion, because ordinarily there is no basis for that. You look at extant position of the law, extant position of the courts. As we speak now, yes, there was a comment by the Supreme. In fact, I won't even call it obiter, because it was just by the way. It was not even well spelled out by the Supreme Court. They just say, oh, unfortunately, some people have suffered for this similar position that we are pursuing here. But as it is, unfortunately, there is nothing we can do about it. And ordinarily, that is the position of the Supreme Court. It has not changed the decision of the Court of Appeal. As bad as people might feel the decision of the Court of Appeal is, that is the extant position on that issue now. Meaning that, and when you ask me, the certificate of return has been given to the 16 APC people in order not to generate, because like I said something, and I will continue to say, number one, the Court of Appeal is the last court on that issue. Issues of jurisdiction will arise whether we like it or not. But then, having said that, we all know that there is injustice somewhere. And like I said sometimes ago, I said, well, it's about a tiny window requiring a tiny thing to get to solve the problem, to pass through. Now you need a strong-hearted lawyer, because as far as I'm concerned, if a lawyer chooses that I want to litigate, there must be a remediation for what I consider as injustice. Can the court still look at it? Even if the court looks at it, they will not penalize you for coming back, because you truly deserve to come back to the court and ask questions. So apparently for the PDP lawmakers that were sent packing, their best redress should be to go back to the court. I'm aware they went to one was the state high court, and maybe the state high court was of the opinion that look, it doesn't have jurisdiction over that matter. But I think you can go back to the Court of Appeal itself and ask for a review. If they didn't give it to you, go to the Supreme Court. Who knows? Something might just happen there. But having said that much, the best that we can have now is not going to the chambers to create a scene. No, you don't have to do that. You are not the first person that will be that will receive what you don't consider as palatable. You are not the first person that will come out to say, look, I was not justly treated. Mandela was not justly treated. He went to prison. He came out of it. He became Mandela that we are talking about today. So apparently, you are not the first person. Whether you like it or not, that was how the justices of the Court of Appeal saw it. It was not because they were against you. It was not because they hated you. That was their understanding of the law. And as far as I'm concerned, that was the best anybody could have done under that situation. But like I said, you can go back to seek a remediation for what you consider as a palpable injustice in this wise. And for me, really, I won't see any lawyer being blamed for coming back to court. I won't even see the litigants being blamed for coming back to court. But having said that, I don't really think anybody should go, the PDP people should not go to the House of Rep or the House of Assembly to create any scene at all. You are being edged out. You might say technical, whichever way, there is a judgment of the court that says you are no longer legislators. Go back there and see what can be done. Otherwise, you wait until 2027.
Yeah, but of course, the main issue has to also do with that. Those lawmakers has failed to be recognized, you know, because I think the one sitting feels that there is a confusion somewhere, that probably there has to be direction.
I think basically the speaker and other members of the House of Assembly, they should not pretend that there is a confusion. There is no confusion. That's the truth. The position as we have now is that the lawmakers of the APC stock, about 16 of them, have been given certificate of return until it is withdrawn officially through another court process. You have to recognize them. They shouldn't create crisis. And you know, this is how this state of emergency of it starts. I think they should not tamper with what has happened. Okay. Rather, they should pursue the redress that is open to them.
All right. Professor Deji, you know, last week we had the opportunity to say that you schooled us on the meaning of the Latin max ubi jus ubi remedi, and you said that it meant that wherever there is a right, there should always be a remedy. And I'm sure that these PDP lawmakers had what you said last week, and they have taken that ubi jus ubi remedi to the House of Assembly, you know, to enforce their rights, because they feel that where there is wrong, there is always a remedy. And they have taken it a notch, you know, to go and occupy their rightful seats at the assembly, which, of course, according to them, their rightful seats. So what do you have to say, and what do you advise that they should do in order to get the remedy that is in this Ubi remedy.
Yeah, thank you very much for what you have explained. Except that when we were discussing last week, I did not say they should take a political option.
Okay.
What they have done now is taking a political option.
A banditry option.
And that's not it. What we're advising was that they would need a remedy from a court. Well, the only modality was that my colleagues on the other side was of the view that since that court of appeal is the highest court, as far as the matter is concerned, they cannot do anything, and that court is functions official. And I stated that there are two methods that they can adopt in seeking their remedy. All right. The first thing is that the court of appeal that gave that judgment has a right to set aside his own judgment, particularly more so since that judgment itself was declared by inquiry by the Supreme Court. By virtue of that judgment of the Supreme Court, it has rendered the decision of that court of appeal given par inquiry. And the court of appeal, even though where we disagree was the question of whether that court itself can set aside his own judgment.
Yeah,
now the court of appeal sitting as a court of appeal has no power to set aside his own judgment. That is the position of the law. But a court of appeal sitting as a final court in respect of the judicial determination of the right of a person has an inherent jurisdiction to set aside his own judgment, just like the Supreme Court have an inherent jurisdiction in certain exceptional circumstances to set aside his own judgment as the highest court in respect of judicial causes or matters that are brought before it. That's one method, that's one route that they can adopt to try out the legality or otherwise of that judgment. Now the second route, which I also suggested, is the question of the Attorney General of that state raising up an issue on the basis of case stated told the Supreme Court that in view of the judgment of the Supreme Court that had determined the issue of the governor and the legality of the pre-election matter being used as the basis for an election petition case, what is the fate of the House of Assembly or the legislator or the same state? The Attorney General can frame that case and present it to the Supreme Court in the light of the judgment that had been given by the Supreme Court. Now the Supreme Court will now have overview the opportunity of revising the judgment of the Court of Appeal in respect of that state. It will not be a question of looking at the judge, because as far as the judgment is concerned, just like the letter 6 said, the judgment stands until it is set aside by a court of law. So it is only the Supreme Court, either through the Attorney General raising.
And it is not possible for High Court to set aside.
No, the High Court has no such jurisdiction.
So they are going to High Court was just
a waste of time. And the political option also is another waste of time, just like the letter 6 have said. The political option cannot resolve it because the certificate had been issued out to the APC.
And yours has been withdrawn.
And yours has been withdrawn by virtue of law, by operation of law. So obviously, the only way to go is either to go back to the Court of Appeal, and based on the inherent jurisdiction of the Court of Appeal, they can set aside, the Court of Appeal can set aside the judgment, with reference to the judgment of the Supreme Court. And let me also say this. I think our law had also moved ahead beyond the question of obiter and ratio decidendi, in respect of judgment of the Supreme Court. If you look at the case of Ifediowa and Ume and Nwosu and the state, it has been said that even if the Supreme Court decide a principle that is not based on the ratio of a case, that principle, if it fall or not falls with other decisions in the lower courts are bound to follow that decision, that obiter of the Supreme Court, because the obiter of the Supreme Court is a pronouncement of law that binds all other lower courts.
So unfortunately, there was no decision by the Supreme Court on that issue, whether obiter or the ratio decidendi. It's one of the justices that just said I feel pity, or I have pity for those who have suffered injustice. That's not judgment, that's not a decision, it's just a speech
out of the other. Well, it will still amount to an obiter. So long as it will still, they can still rely.
Honestly speaking, I think, let me agree with you, like you said.
Even if it's a comment,
review
yes,
by the Court of Appeal, I agree with that. If you go, because ordinarily, if you had sought a review, because some certain things will come into form. Number one, in view of the fact that it's an election matter, do they still have jurisdiction to review?
Yes, the question of the time.
There are so many issues that needed to be. Then, like I said, you need a lion-hearted lawyer to approach them to put all these issues together. Because if you are newly-livered, you might not even stand.
Yeah, you may not
20
get
minutes
anywhere
before they throw you out.
Yes.
And say, "Oh boy, just get away. We don't have a jurisdiction over this issue." But then, if you are lion-hearted and you can argue, you can marshal your issues creditably well, unlike the kind of approach that they are taking now.
Yes.
I think I won't agree with case to be stated by the Attorney General, because based on the fact that there is separation of power, this is purely a assembly matter, and as far as I'm concerned, they should be able on their own handle this issue. That's like mature people, like Democrats who have suffered.
Dr. Adekunle, what I want, when you said that you need a strong-hearted lawyer to really approach this case, are you talking about in respect to the fine that might be slammed? Because you know the Supreme Court has slammed some lawyers, some 50 million, some 30 million, some people are not even worth up to that amount, and they might not appear again until they're able to liquidate that. So when you are saying are you talking about the cost that
number one, like I said, it's like a tiny window that requires a tiny thing. It's going to be a bit dangerous. It's not an issue that you approach like every other. This is an unusual one. You're already caught by the limitation of time. You're already caught by jurisdiction of the court. So for you to come around, you really need to be brave, extraordinary. You need to do an amalgamation of both street sense, lawyer sense, and all together to be able to convince the Court of Appeal to change, because basically they will tell you their hands are tied. It's like my hands are tied of a thing.
Yeah, but we're talking about the cost of even coming, because in terms of precedent, the cost of coming, the risk of being slammed with, people have criticized that in the past, because now it's like tying people that they can't approach the court.
No, if you heard what I said earlier, that is the reason why I said I do not see any lawyer litigating this issue being penalized, because what has happened does not amount, it won't amount to a professional misconduct. Rather, to allay the fears of everybody, to ensure peace and harmony and justice. That is the reason you are coming back.
Fairness
and in order to really expand our law, we are talking about activism now. The justicial status has never been litigated before. Let us look at it. What would the court say? Like the Kano matter. The court said, this is the way we are going. It was an unusual one. Like I said earlier, it was an unusual one. The Supreme Court said, this is the way we will go, thereby making a policy statement which every other court has to follow. So in this wise too, let somebody go in there, ask questions, let these legislators go in, because that's the only way to seek a remedy to whatever has happened to them. Go back to the court. I'm sure no lawyer will be penalized for asking questions, because everybody is confused. Everybody is troubled. Everybody wants to ask questions, even including the justices that sat on that matter. They really want to say, okay, what can we do? Is it possible to redo what the position, or is it possible to just leave it the way it is? So these are questions that needed to be asked. So I'm not looking at cost. That's the truth. But I'm looking at somebody who is brave enough, who is lion-hearted, who cannot be intimidated, who cannot be muzzled, who cannot just be harassed and say, look, Mr. What are you doing? You just what I'm talking about. So you must be a man who can stand, who will look at the face of whoever, or the face of the panel members, and say, my Lord, this is the way I think this matter should go. Put this matter correctly. Let's see if it will advance our jurisprudence.
All right, Pastor Deji.
I want to say something about what the learned sick have just said. I think we must not forget the fact that there is a line of authorities by the Supreme Court that have decided the issue of when a pre-election matter can be handled. And the preponderance of decision or opinion of the Supreme Court had always been that matters that are pre-election matters should not be subject of election petition objections, or even the basis of an election petition matter. That there is a plethora of cases on that. So on that basis alone, the Court of Appeal at the time it was giving that decision was going outside the norm, outside the judicial norm, the norm of the courts, the highest court of the land, in all those plethora of cases, in deciding that a pre-election matter can now be used for an election petition. I think it was out of order, and that's why I said earlier on that that judgment he said was given par incuriam. It was given par incuriam because if all the previous decisions of the Supreme Court had been cited to that court, I don't see why that court would see.
If they should have declined jurisdiction over those issues.
Exactly. At that point.
Okay, yeah, Barrister Deji. That brings us to the point. What do you think could have happened for this kind of decision? Because the issues here is something
I don't want to speculate.
It's something that seemed to be fairly straightforward and
very clear
and simple for every lawyer to understand. So what would have gone under the bridge to have made the highest court, of course, a court that is just below, a step below the highest court, delving into issues that had already been, decided as pre-election matter by. So what could have? Is it that they were confused about the state of the law on this matter, or there were other surrounding circumstances that made them to deviate?
Well, let me say first of all that there was speculation, and I don't want to speculate, but in the course of discussion, a lot of people have speculated that it's just another political decision. In other words, an influence decision to position a particular political party in the state. Well, I don't want to go to that along that track, but my own view is that whatever must have happened, I think this is a major error that needs to be corrected. And for, just like the learned Sikh said, for the expansion of our jurisprudence and the issue of access to justice, a lot of principles, a lot of rules and regulations today are being put in place to hinder the access of people to justice. And that's where we have a problem as lawyers, to ensure that we complain against this decision then to make the Court of Appeal the highest court in respect of petitions that are coming for members of the House of Rep, whereas that of the governor will go all the way to the Supreme Court. Some of us complained at that point, so when it was being mooted, but we're sidelined.
No, but
and the fact is still coming up now.
Barrister Deji, the fact that
the
fact that all cases doesn't get to the Supreme Court shouldn't be the problem.
That's one of the problems.
Should only the Supreme Court be trusted to advocate for cases?
That's not the point. I mean, the effect is what you are saying now, where the Court of Appeal that feels that it is the last court in respect of some matters decide something different from the set of norms that the Supreme Court have set down over the years, and they don't feel bound by it. What happens? That's why we're having this conflict now.
Yes,
that's why we're having this problem now.
Dr. Legule, even before what happens, the question is that, why I ask the question is that because the issue are already on ground. Should it be only the Supreme Court that should be trusted? After all, the Supreme Court justices are drawn from the Court of Appeal justices.
Yes.
So there are basic elements of law or decision or accuracy that is expected from that court. For the issue at hand, this seems to be a straightforward issue as has been espoused by you. So what would have gone wrong? Is it that they need more training or what?
No, I think what we all need to do is, number one, I'm not in a position to justify what the Court of Appeal justices did, and I'm not in a position to even condemn what they did. But I will put it this way: as the last court to look into that matter, they are infallible. That is not to say that they cannot commit error. Supreme Court once in a while.
No, but that is not only to say that they should also commit obvious errors.
I'm coming. So if we have that, I'm not saying that we should justify the fact that they fell into error. The error is becoming very glaring now simply because the Supreme Court has said, yes, we disagree with your decision. Otherwise, every one of us perhaps would have kept quiet because nobody was saying anything. I will say that without missing word. That before this matter, before Muftuan matter went to the Supreme, even the prophets, they came out. They said, we see Muftan losing in plateau. Abba is losing in Kano. They came up with all sorts of things, and that Fubala's leg is shaking and all whatnot. So it was like everybody was looking at it. Yes, if they could decide this way, but then with the insight of the fact that look, there was an arrogance on the part of PDP originally. There was a decision of the lower court that says, no, you cannot conduct, the primary should not be conducted by a particular faction. Are you with me? And you know, at times, if you disobey a court order, that might have some impact. Rather than having to look at it from political angle, for me, really, I don't see it as an issue. No judgment because of political understanding or what's the interest of Court of Appeal in APC? What's the interest of Court of Appeal in PDP? Theirs is to do justice and leave the state. So ordinarily, I want to believe that so many things might have ran through their minds as well. Number one, there was a disobedience from onset, and it was on the basis because if you're asking questions, the tribunal comprised of judges, isn't it? About 5 or not? About 5.
Yeah, the tribunal gave judgment.
Three of them at the tribunal level. They decided that way.
Yes.
Now they came to the Court of Appeal. The Court of Appeal decided the same way. So meaning that, because ordinarily if you put I and my Ghanaian brother together, we might disagree on a lot of things that look so simple. It might look very, very simple and ordinary that we keep dragging between ourselves. Put 8 lawyers together, we might have 8 different...
But let's see. You said that a line of decision on this issue of election matter had already been decided. So it's like a doctor who is well trained making an obvious mistake. Shouldn't we be worried?
No, when you look at it...
Should we now say they are infallible, that they can make mistakes whenever they want?
When you look at it very well, like the decision the Court of Appeal decided now, it's not different from what they had in Rivers sometimes ago. It's not different from what they had in Sokoto sometimes ago. The only difference in this, which I think the Supreme Court has been able to use to get Muftan out of who was because the issue was not pursued. You know, the Kebion was pursued by Marafa against Yari. So apparently, as you see, it's a tiny line. I don't really see us blaming them. It's a decision and it is final, whether we like it or not. But the fact that it is final does not mean that it was right. So let's begin to look at it from that. Let people live by it. Let us then ask themselves questions. What do we do about it? If these men were to be at the Supreme Court, they are all fit to be at the Supreme Court. Assuming it was the Supreme Court that said what they are
the Supreme Court has done similar things.
The same way. So what are we going to do? So let's give them that benefit of the doubt that yes, it may look slightly erroneous, but apparently, or like my learned friend said, what did you call it again? Okay, I'll come back to that. But then let's assume.
No, but let's see. You say it might look slightly. Are you saying that it's not erroneous, or it might look slightly erroneous?
Let us
not as a lawyer who have studied this case. Are you saying that decision was not erroneous, apart from what the Supreme Court have said?
Oh, my position is that
yes,
it is erroneous.
Exactly.
It is erroneous, but that does not mean that I am right. That does not mean that they are wrong. As at when they were giving that judgment, that was how they saw it. Even when Supreme Court finishes with any of its matters, even for my cases, I've lost cases in Supreme Court that I ask myself, oh, how could this case have been lost? Do you understand? Apparently, the way I looked at it was different from the way the justices looked at it. So I think we should agree, one, that because Supreme Court said this by passing, then that means the decision was erroneous. But as far as we are concerned, that does not make them less competent. Let us not.
No, nobody is talking about
They are
this.
extremely competent. That was the way they saw that case, and that was the way they decided it. And they can, they enjoy judicial immunity. They can't be wrong. They enjoy judicial immunity. That was the way they saw it. Even there is nothing the Supreme Court can do about it. If anybody will review what was decided, it has to be that court, and they have a discretion not to review it. If you bring an application, because if it is not reviewed by that court, Supreme Court cannot touch it.
Yes, of course, we know they have the discretion, but we also know that they have the responsibility to do justice.
Yes.
And justice has to be seen by people and acknowledge that it is justice. Obviously, almost all lawyers agree that there were obvious errors, not because of how they see it, but because of what the law says on those issues. And the law was clear.
And it is not a new thing for judges not to see. That is what a perverse. That is why you see that you look at judgment or certain can say it was a perverse one. Apparently, this might be one of it, but it does not mean that they were biased. It doesn't mean that they didn't know what they were doing, but that was how they saw it.
Yeah, but the question is going forward.
I wanted to say this. Falling out from what the learned sake said. You see, this is one instance where our court should be cautious. It is true that this judgment went the way it went, and that's the way the court saw it at that time. But how did they come to that conclusion? Perhaps it is as a result of their state of mind of the case and the way it came.
And not the state of the law.
And not the state of the law. That's why I say it's par incuriam. And I will tell you what I mean. Now the panel that sat decided against the legislators that the primary was not done properly. All right? And in a bid to disobey that order, they went on appeal. The court, and they did not obey the lower court, the panel. Now it will appear as if the court of appeal was angry with the fact that they did not comply with the primary properly.
That's a pre-election matter.
Yes.
That's pre-election matter.
And having said that, we are all looking at the conduct.
But shouldn't they be concerned about the state of the law or not the state of the mind?
At that point,
I'm coming. For as much as we are looking at the conduct of the judges,
yes,
we should ask ourselves questions too. The conduct of the so-called system legislature,
yes,
including the governor.
Yes.
When there was a judgment that says,
yes,
do not go high,
yes,
without primaries.
Yes.
So at times
I think it was where the error came. That was the attitude of the court of appeal was to at least instill some discipline.
Yeah, but the other party should have contested at the state of pre-election matter. That's why we have pre-election and post-election matter. So if you have failed
if I were to be a justice of the court of appeal, perhaps that too might have affected my way of reasoning. You see, we need to be fair with ourselves. As much as I know that yes, it was peculiar, it was perverse, it might not impress in view of all the other judgments of the Supreme Court, it might not be the best. But then we should ask ourselves, they are paid for their sins as well.
All right. We'll go on. Of course, it has been a heated one at the studio this afternoon. We'll go on a very short break, and when we return, we'll take the issue concerning the reverse budget to the presentation. Stay tuned. We'll be back shortly.